Hey, good morning, everyone. My name is Raven Willis, and I'm the administrator in the group. If you guys are watching me from my personal page, I'm going to share this, then why don't you go ahead, and if you own a business, then why don't you go ahead and join my group, Free Legal Resources. If you are watching this from my business page, which is New Millennia Legal Resources, then go ahead and join my group. But again, my name is Raven, and I am the administrator in the group, Free Legal Resources, and I'm a lawyer in Texas, Keller, Texas, which is right outside of Fort Worth, and I specialize in contracts and, well, all things contracts, basically writing, negotiating, reviewing, monitoring contracts. That's what I've been doing for the past about 17 years. So if you were on, let's see, on Tuesday, then you already kind of know the series that I'm doing. So what I'm doing is I'm focusing on service contracts, and I'm walking through some of the red flags that I've seen that are pretty common in service contracts. These aren't necessarily industry specific yet. However, I'll probably get a little bit more into different industries a little bit later in the next coming weeks, in the next coming months. I'm going to try to do that. But last time I talked about work statements and making sure those are tight. Just to touch on a little bit of those points, I said make sure that you're very detailed. Details are your friends with any contract. Really, details are going to be essential to a really good contract. So make sure they're detailed. Make sure you describe the work as specifically as possible. Make sure there are no contradictory terms in that statement of work, and make sure that the points of contact and the different who has what authority is specified in that statement of work. So that was the other day. If you guys missed that video, then you can go back and take a look. If you're in the group, then you can go and take a look at that video that's there. So today I wanted to talk about the fee clauses in the service contracts. And I think this one probably will be pretty interesting for most folks. Sorry, my cat keeps trying to get on my lap, pushing her up. So the fee clauses, it's really important because obviously those clauses are what's going to allow you to get paid. And the fee clauses are sometimes not as clear as I think they could be, because you want to be able to recover, obviously, your fees as easily as possible. So some of the things that I wanted to go over, and actually I'll start. So the first thing is you want to be as specific as possible. Again, details are your friends when you're dealing with anything pertaining to contracts. So in those fee clauses, specify how much. It seems obvious, but not necessarily. Things that seem obvious don't always make their way into the contract. So be as specific as possible to say how much, how often you're going to bill, if it's going to be weekly, if it's going to be biweekly, monthly. Let's see, if it's a date that the fee is going to be due by, make sure you specify what that date is. When is it going to be considered late? And what late fees you're going to have associated with that. Now, late fees are pretty interesting because if it's a contract that's a B2B contract, meaning it's a commercial contract that you have in place with another business, then you can actually, you probably can charge as much as you want, what's called like usury fees, like late fees, an annual percentage rate or something like that if it's late. There's not any, generally there aren't any usury prohibitions on how much you can charge for that if it's a B2B contract, if it's a commercial contract. Now, if your service contract is with an actual consumer, an individual, then there might be usury charges, so you might be limited as to how much you can charge for those fees. That's determined on a state basis, so you can look those up if you guys have questions about usury fees. I mean, I can probably help you look that up. It's pretty easy to find. So if it's, like I said, if it's a business contract, then, you can pretty much specify, generally you can specify however much you want for those late fees. And also for the fees, you want to, as much as possible, tie those to a milestone or tie them to deliverables. This way it's easier if you say if the client or a customer terminates the contract early, then it's easier to recover your costs and you haven't necessarily put all of your fees at the very end, waiting for them to accept, whatever deliverable, or waiting for them to approve. But if you tie them to a milestone, if they do cut it off early, then you're still pretty much even. And also, what you can do is, if you tie it to, okay, so if they suspend services, what you can do also is have a kill fee. So if it's not really feasible to tie it to certain milestones, you can tie it to a kill fee. So if it's a year-long contract and they decide after 6 months that they don't want to continue with it, then you can just build in a fee that way, instead of again waiting to the very end of the performance. And then after people receive the full benefit, as a lawyer, I've experienced this, and I know probably T, you're a lawyer T, you probably know exactly what I'm talking about. So a lot of times when you put the payment at the very end and after the party has received the full benefit, that sense of urgency isn't there anymore. And so it's more common for them to, terminate or be slow in paying the fee. So, anyway, so you don't necessarily want to wait until the very end of it. But if you absolutely have to, and it's just not feasible, then definitely build in a kill fee. Let's see. So also, this is really, really, really important. I say this all the time. All of this is important. It's all very important. But this is really important. Reporting to a credit bureau. If the company is pretty established, this actually might be a very good tactic, a way that you might be able to kind of threaten the other party if they're slow in paying, is you want to be able to report them to credit bureaus and credit agencies. And you can't just do this if you don't have the right terms in your contract. So you want to make sure that you have language in the contract that allows you to disclose their confidential information. So their EIN number, their address, their name, it might be perceived as confidential information. So you need to make sure that you have that language built into there. And this is also important. A lot of times, non-disclosure agreements or confidentiality agreements explicitly state the opposite. So you need to go in and you need to make sure that those two are consistent. If the non-disclosure language is already built into the contract, then this will be probably a little bit easier to do. However, if it's a separate non-disclosure agreement, you need to go and make sure that the terms are consistent. Because remember, if there are any inconsistencies between the two documents and you're the one who wrote that contract, or you're the one who had somebody write the contract, it's going to be construed against you and in their favor. And so you're not going to be able to disclose their information if there's any type of inconsistency. So I say that to say, make sure that you include that language in there that's going to allow you to disclose their information to just a credit bureau, or say you can make it general, like a third party for debt collection purposes, and then make sure the non-disclosure agreement, if it's a separate agreement, is consistent, and then also make sure that non-disclosure language and the rest of the contract is consistent with it as well. So let's see. Non-disclosure agreement, that's very important. So the kill fee, make sure you have a kill fee in there. Make sure you have it tied to milestones if that's applicable to you. And if not, like I said, have a kill fee. Make sure you specify in detail how often you're going to expect your payment, when, if there's a specific date, when you're going to expect that payment, when it's going to be considered late, however many late fees or however much as a late fee you want to have in there. And for if it's a business to business contract, then you probably will be able to charge as much as you want for that late fee. If it's a business to consumer or business to customer contract, you're probably going to be limited in that. So you can look that up. It's just look up usury laws and then your state if it's a B2C contract, and you'll be able to tell what that is. So hey Andre, I see you joined. So, okay, that's pretty much it for the fees. Now tomorrow, well, probably not tomorrow, maybe tomorrow, maybe Monday, I'm going to talk about dispute resolution clauses in your contracts. You want to make sure that you have some mechanisms in there whereby both parties can try to work through your problems instead of having nothing in there and having to go to court, because if you've watched my lives before, you don't necessarily win all the time if you have to go to court, because it's just going to be too expensive. So I'm going to talk about ways that you can work dispute resolution clauses into your contract to kind of help prevent that. And in the end, it's going to end up saving you some money. So, all right, you guys, that is it. This was quick. If you guys have any questions, let me know. Leave a comment down below, and I'll be on today probably in about an hour or so. I have some stuff I got to take care of, and I'll answer them for you. Thanks, guys, for joining, and I'll talk to you guys soon. Bye.